Okay, let's get started. The topic right now is negotiation. How to negotiate just about anything. Obviously, as attorneys, we are all professional negotiators. This is one of the main things our clients expect us to do for us. And we all think we know how to do it, but there's a lot of myths about negotiating, which I want to sort of dispel as part of this presentation. First of all, my legal disclaimers. Once again, anything that I say here is strictly me. It's not Thompson West or anybody else saying it. It's just me. And I'm not giving any advice here, so if anything really bad happens, if you hear something from me and you like it and you follow it and it doesn't work out and everything happens, you lose your job, your spouse divorces you, your dog pees on your leg, and you end up, living on the diaper box under a Brooklyn Bridge or something like that, you cannot sue anybody in this room. You can't sue me. Nah. Okay. That's it. End of that. Okay. Business is all about negotiation. I mean, negotiating is one of the three essential business skills. The other two are selling and bookkeeping. If you know how to sell, if you know how to negotiate, if you know how to keep the books and records, you are an entrepreneur. You can run a business. Those are the three essential skills. Everything else is gravy. And when you're in business for yourself, and of course as a lawyer, you negotiate every day. Not just with the opposing side. You negotiate with your partners. You negotiate with your employees, with the staff if you work for a law firm. Just about everything you do, in your daily life is a negotiation of some form or another. But here's what negotiating isn't. Okay? Negotiating is not a search for truth, justice, and the American way. There is no such thing as a perfect deal. There's no platonic ideal form of a perfect deal toward which you aspire when you are trying to negotiate a deal. I think a lot of young lawyers start out with that idea, and it's not true at all. There's no such thing as a perfect deal. It is also not a friendly discussion over a cup of tea. It is not. There is not a quest for it's not a quest for perfection, but it's also not a battle, argument, or confrontation either. Although some negotiations, if you listen to them going on, they sure as heck sound like people just aren't happy. But but it's not a battle. Okay, that's what negotiating isn't. So what is negotiating? Very simple. It's a game, and a very specific game. It's poker. Okay. One of the things I can tell you after 35 years of practicing law, good poker players are almost always good negotiators. Almost always. There's a real high correlation between those two things. Now let's think about poker for a second. Poker is a very simple game. A dealer hands out a bunch of cards to a bunch of players. They look at them, and the goal is to try to build a specific hand. And there is a hierarchy of different hands. Okay, and the idea is to get the highest ranking hand you possibly can. And at the end of a certain number of deals, there's different numbers depending on what kind of poker you're playing. Everybody lays their cards down, and whoever has the highest hand wins the pot. Now, if that's all there was to the game of poker, there would not be a poker channel on cable TV. It would be an incredibly boring game. Okay, what makes poker so exciting is that while all this is going on, there's bidding. Everybody's trying to psych out each other and figure out who has the highest hand. You've heard somebody say about somebody that they have a poker face. What that means is that they're very hard to read. I can't see the cards, by the way you, what's the famous line from the Kenny Rogers songs? I can't figure out the cards by the way you hold your eyes. I can't tell you that. You can have the world's best hand in the world. You can get a royal flush, which is the highest hand in poker, I think. 5 aces might beat it. 4 aces plus the joker. But the royal flush is the highest hand. You could get a royal flush on the very first deal. No question you're going to win this game. But if you take the cards, you go like, you've just lost because all the other players know what you got. They know you got something good, and they're going to fold. You'll end up with maybe a couple of quarters or something in the pot. The idea is to hold back your emotion, and then at the very end, very dramatically, you lay out your royal flush. That's the whole purpose. I have been in poker games, quite frankly, where some very horrible hands ended up winning the game because of how the players handled that. I actually saw a poker game once where the guy only had a pair of threes. but he was able to convince the other side through his bidding strategy and his facial expressions that he had something a lot better, and as a result, he ended up winning quite a sizable pot, with just a pair of threes. A guy actually had a straight flush who folded to this guy's pair of threes. I mean, it's just an incredible. It's not so much what your hand is and the cards you're dealt, it's how you play them. By the way, a great metaphor for life. I mean, poker is a great metaphor for life, I think, just in general. But it's a very good metaphor for negotiating. I mean, don't get me wrong. It helps if you have a stronger case, if you have a stronger negotiating position. But if you don't play the hand right, you and your client may end up losing the negotiation in the long run. Also, even a bad hand can be a winner if it's played properly. The goal in any negotiation is simply to get the best deal that you can for you, if you're the one doing negotiating for yourself or your client. Okay, what's the difference between business and contract negotiation? Well, most business transactions, there are two different stages to the deal. First comes the business deal, and then comes the legal negotiation. Now, sometimes we attorneys do get into the business deal. I actually get involved quite a bit in my clients' business deals. Most of my clients are people who've never done this particular type of transaction before, and they're looking for me not so much to help them just do the documents, but also to help them structure the deal. If you're involved in deal structuring at all for your clients, you are helping on the business side as much as you are on the legal side. Mostly the clients want to do their business negotiation themselves. But I always tell young attorneys especially, try to get involved as early as possible in the negotiating process. A lot of difficult negotiations can be resolved at what I call the letter of intent stage. In any sizable transaction, the clients are not going to go directly to the legal documents. What they're going to do is they're going to do a term sheet of some kind. It's not a legal document. It's usually only a couple of pages long. It consists of bullets. And what it describes are the basic business terms of the deal. So let's say, for example, you're representing a client who's buying a small business. Okay? The term sheet will talk about what the assets are that the client is buying. Or is it stock? Is the buyer buying the stock of the seller, or are they buying the assets? Very important for tax purposes, which way that goes. If it's the assets, it'll have a brief description of the assets the client is buying, what they're not buying, what the purchase price is going to be. Is it going to be all cash? Is it going to be payable over time in the form of a promissory note? All that stuff is going to be laid out. It's not a legal document. In fact, at the very end of it, there's a paragraph which you should always make sure is in there saying this is not a legal document, this is not a meeting of the minds, this just reflects where we think the deal is at the moment. It is all subject to definitive legal documentation and yada, 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 so that if a party wants to walk away from the deal at that point, they absolutely can. I spend a lot of time on letters of intent with my clients. I do. Oh, another name for them, they sometimes call them a memo of understanding, or MOU, same basic thing. I try to do as much as I can in the letter of intent. Why? Because it makes the legal negotiation a lot easier. The more you can get your client to agree to up front, the easier the negotiation will be out the back end, and in my case, the lower the fee to the client, which is important. I represent clients who are very price sensitive. They do not want me spinning wheels. If a big mistake that novice lawyers sometimes make is they try to negotiate the business deal and the legal documents at the same time. That is a mistake. What ends up happening then is you go through multiple drafts of documents, 3, 4, 5, 6, and the only people making any money at that point are the lawyers. I hate to say it, but it's a very major mistake, I think, that novice lawyers make. What you try to do, and especially if the client is sensitive to price, you try to get as much done in the letter of intent stage as possible so that the legal negotiation will go a lot easier. The fewer issues you have to deal with at the document stage, the better. Once you get the letter of intent in place, now the lawyers take over, and you draft the definitive documents. So again, we're buying a small business, the purchase and sale agreement, the bill of sale, the non-compete agreements that the seller and his principals are going to have to sign. Now here your client is expecting you to take the lead here. Clients do not like drafting legal contracts. There's no two ways about it. It's dull, it's boring, and it's scary, too. Make one mistake, and you can be sued for malpractice. Okay? Which is why clients are only too happy to have us attorneys take over that responsibility. And it can be scary, especially if you're dealing with a letter of intent that's very sketchy, where a lot of the business terms have not been worked out. There you're in a position where you're going to have to do some business negotiating at the document stage to get the deal on paper the way it absolutely should be. Now, so what happens here? Okay, if you are preparing the initial drafts, by the way, I also cover this in the letter of intent. Who is going to draft the documents? okay? Whoever's lawyer is drafting the documents is going to have the bigger legal bill, number one. It takes a lot because when you're drafting the documents, you're playing two roles. You're the negotiator, but you're also the person in charge of the documents themselves, getting the language right, doing the proofreading, making sure that when the document goes out to the other side, everything's there the way it should be, making sure all the redlining and blacklining is done properly. You have a much bigger administrative role in the transaction when you are the one drafting the document for your client. So there are two reasons why you should always fight to be the one who drafts the documents, okay? First of all, if you're preparing the initial drafts, you get to write it your way. You get to put in the provisions that you feel are necessary for your client. If the other side is drafting the documents, then you're in much more of a defensive role. Your job is to look at what the other side has done and fight and push back on things that are too aggressive, things that your client probably would not want to sign or would need some protection. I always say that when the other side is doing the documents, I'm climbing a pork chop hill here. And what I have to do at that point is I have to basically compare the seller's document to my document, my standard document, and then tell the client all the things that they're not getting in the seller's document and get the client to decide which ones they want to fight over and which ones that they don't. This I do for malpractice reasons. My malpractice insurer is very happy that I do business this way. When I sit down with the client for the first time, if the other side is doing the documents, I sit down with the client and I say, Joe, just to let you know, I mean, we're not going to fight over all this stuff, but I think in doing my job, I have to point out to you all the things here that you are not getting. Now, some of these things are worth fighting over. Some of these things aren't. We're going to talk about that. But, I want you to know everything that's not in there because that's what I need to do my job. Also, what I'm not telling him, this is what my malpractice insurer wants me to do. Because inevitably, if you leave out something, if you don't fight over something, Murphy's Law takes over, that particular provision causes a problem, and the client is never going to remember that they gave on that they said, okay, Cliff, don't worry about that. They're going to come back and say, you son of a gun, why did you not tell me about this? Document everything. We're going to talk about that in a little bit, about how you document it when you're doing negotiation, how you document stuff. It's very important. Okay, always, whenever a client concedes a point, or says, Cliff, don't worry about that. I'm not worried about that. It ain't going to happen. Get it in writing or by email. Now, I am not a big fan of email. I mean, most attorneys aren't. Put 10 attorneys into a CLE program like that. Everyone's going to say, be careful when you send out stuff by email. And of course, they're all right. But there's one place where email can save your butt, and that is here. Whenever a client says, Cliff, yeah, I know that. I understand that, but I'm really not worried about the governing law clause. Let's leave it California. I don't really care about that. Great. Just make sure at some point you do an email to the client saying, just to point out, we agreed that we're not going to fight over the governing law clause. Just have it in an email to the client. And then what I do, now, of course, being older, I'm a little bit more, I'm a bit more of a jerk about this, but whenever a client makes a concession, I not only send an email, I print it out and I put it in the folder. Because inevitably, if something blows up there and that client forgets that they told me not to do something for them, I want to be able to grab that piece of paper within 30 seconds, scan it, and email it to them saying, by the way, you told me on August 24th, 2013 that I was not to do that, so I didn't do it. I followed your instruction. That email can save your practice, and your malpractice insurer will. Don't get me wrong. Email is email. Let me just sort of do a little digression on email. How many people here use Gmail or Hotmail or Yahoo for their accounts? Of course, your firm obviously won't do that. They'll have their own internal system. But if you're on your own, like I am, if you practice naked, like I do, you use one of these things. One of the hardest things you'll ever have to do is back up a Gmail portfolio. There are utilities that are very good that will help you do it. But whenever you try to back up your Gmail account onto a CD or other physical medium, what happens is the utility, it does it beautifully, but it does it in strict chronological order. It removes the heading saying from who to who. It also, if you have different files for different clients or different things, it removes that as well. It just takes all those emails from your Gmail account and copies them in strict chronological order with a timestamp. So you've got a CD with 5,000 emails on there, but when you go to look at the emails, all you see are the times that the emails were done. You've got to go through each one of those and figure out which are the ones that relate to your matter. If you are sweating an angry client who thinks that you did something wrong when you didn't, you want to lay your hands on that email within 60 seconds. Make a copy, keep it in the file. You know, smoking, I actually keep files, a folder in some of my client files, smoking gun emails, I call it. You know, these are the 5 emails I want to lay my hands on. If this client turns out to be trouble down the road, I want to lay my hands on these 5. Do that stuff, because it might very well save your life, you know. Okay, the last reason why you want to be the one drafting, I mean, what I'm really talking about here is why should you be the one to draft the document? Number one, you can charge more money, because, you know, whoever's doing the documents, you know, always runs up the higher legal bill. Secondly, you can do a better job for your client because you'll get all the right stuff into the first draft and make the other side fight defense. You know, thirdly, you can thirdly, you know, contracts, the thing you have to watch out for, contracts in New York as elsewhere are always strictly construed against the party drafting them. In some larger deals, you will see a little clause at the very end in the miscellaneous section saying that the contract will not be construed against any particular party, yada, yada. Make sure that that appears in all your contracts, by the way, because it could save you. If you're the one drafting and there's a mistake, the contract may well be strictly construed against you if you're the one drafting. That's the one reason why you might not want to draft the contract. Let the other side do it. Having said that, you will get into situations where the client will say, look, I don't want to run up a big bill here. Let the other side draft the contract. Let them run up the big legal bill. I just want you to spend a couple of hours reviewing this thing. If that happens, don't assume that you can just skim it over, look for nuclear war issues, and just bring those up. What I do, I go through everything, and I just sit down with the client on the phone, and I go through as much as I can possibly think of because I want the record, the future record, that we talked about those things for malpractice purposes. The wimpy client. You will have this. I get them all the time. Usually they're downsized corporate executives who are going into business for the first time. They've got their first deal. Usually they're consultants. They got the first consulting contract with some big company. They've asked me to do it. Cliff, now I really want you to protect me here. Here's this 30-page contract that this big company wants me to sign. You know, do the best job you can, but please don't kill the deal because I really need this. My wife and kids are ready to kill me. I've been out of work for 6 months. Don't kill the deal. What do you do there? I call that the wimpy client, okay? And you will find them. You know, in fact, my whole life can be said, The Diary of the Wimpy Client. That is a book I'm definitely dying to write at some point. You know, you got to protect your client, but he doesn't want to lose the deal, right? So that means you kind of have to pull your punches, okay? First thing you need to know is the rules of ethics. Under New York's model rules of professional conduct, you can, by the way, you know, help your client, you know, with this stuff. You don't have to limit yourself just to the contract drafting and the legal analysis. You can do what the client is asking you to do, but make sure that you're comfortable doing this. You can take the lead, in other words, on the deal, but make sure that the client okays everything in writing, because under the rules of ethics, the client always has the final go, no-go decision on things. You do not. So if the client wants you to take a more aggressive role, if they want you to be the one to make more of the judgments of what goes in the contract, what doesn't, you can do that ethically, but always, again, make sure that the client okays everything. If the client makes a concession, Cliff, don't worry about that. The indemnity clause, forget, I don't care about indemnities. We'll worry about that later. I just want to make sure the numbers are right in the contract. Fine and dandy, but get it in an email and print the email out. Keep it handy because 50-50 chance you may need it. Clients have a nasty habit of becoming unwimpy when the you-know-what hits the fan down the road. They don't remember that they were wimpy. They don't remember that they told you to back off on certain points. You're the one who's got to remind them at that point, or you're going to have to put your malpractice carrier on notice. Okay, I'm going to introduce you to somebody here. This was my mom, Ruth Ennico. She passed away last year at the age of, what, 83, I think she was? No, 86 she was. And of course, my mom and I were great. I was an only child. Every only child is close to his or her mom. I mean, that's just a basic rule of thumb. But my mom, among other things, was one of the best negotiators I ever knew. My mom was a flea market queen. She used to do, I mean, this is back in the days before eBay and Etsy. She used to do flea markets. I grew up in Westchester in Yonkers, just north of the city here. And, you know, she would do flea markets like every other weekend. And she would drag me along to these things. You know, she was the brains, I was the muscle. I was the one who was carrying all the boxes, wrapping everything. She was the one who would talk to the people and to handle the money. That was our division of labor for several decades. I was doing this since I was a kid, helping Mom out with things. And my mother was one of the greats, all-time greats, I have to say. She wasn't very prepossessing. She was just this little cute, tiny little old lady with blue hair. She'd be sitting behind her card table with this bunch of stuff. You get up, you come up, take a look. She starts talking to you. You start talking back to her. She was a sweet little old lady. Everybody loved my mom. And before you knew it, you were buying $500 of crap you absolutely did not need. Mom had this gift, sales, negotiation. She knew it all. She was one of the most gifted negotiators, and especially non-lawyer negotiators I have ever worked with. And these were some of the things that she taught me about negotiating. I mean, these are some basic principles, but I think it's kind of cool to bring Mom into the picture. You can never get a bargain on something you really, really want. This is the first law of negotiating. You can never get a bargain on something that you really, really want. If you're in any negotiation, your goal is to convince, remember, this is a poker game. Your goal is to convince the other side that you are in the stronger position and that they need the deal more than you do. If we're in any negotiation that I've ever been in, business or legal, whoever needs the deal more is the one who's going to do all the giving up, all the conceding. That's just part of poker. My job in a negotiation is to at least send the signal that my client is in the stronger position. Now, sometimes it is. Sometimes my client is absolutely in the superior bargaining position. The other side needs the deal much more than my client does, in which case this is easy. The harder part is the situation where I'm dealt a pair of threes. The client is a wimpy client. They're afraid of losing the deal, but at the same time, I don't want them being sold into slavery. So I want to make sure that there's some basic protections there. My goal at that point is to do a little bluffing and to let the other side know that my client is in a stronger position. One of the first things you have to do in any negotiation is to get the other side's respect. And that's important. If the client thinks they can just walk, if the other side thinks they can just walk all over you, they certainly will try to do it. Okay? You cannot be nice in a negotiation because other people interpret that as weakness. Unfortunately, that is a fact. Don't get me wrong, you got to be ethical, no issues there, but being nice will get you killed in any negotiation. People don't see it as being nice, as being a lady or a gentleman. They see it as weakness. They see it as a signal that your client is in the weaker position, and they will start pouncing on smaller and more insignificant points. You got to get their respect. You got to get them to know, look, the deal's going to be a fair one, but I'm not going to let you walk all over my person here, my client here. It's got to be a win-win for everybody, or else my client is prepared to walk. Okay? I mean, if your client can't do that, I mean, because they really deal more, and they've already shown the other side that they feel that way, well, then there's not a whole lot you can do. At that point, I'm playing defense, and I'm just trying to keep out clauses that are illegal. At that point, if I can do, I mean, at that point, I'm not going to be able to do much more for the client than that, quite frankly, if that's the case. If the client is wimpy and has shown the other side that they are wimpy, well, there's not a whole lot I can do. Everybody's going to know that I'm faking it, that I'm bluffing. And those are my most unpleasant negotiations because I spend most of my time doing memos to the file that I cannot charge for. Okay, let's talk about how you prepare for a negotiation. Okay, first of all, do some thinking. Who really is in the stronger bargaining position? How does each party perceive their position? That's more important. Sometimes a client is in a very strong situation and they don't know it. You have to tell them, look, you've got a stronger case here than you think, because of this, because of this, because of this. Exactly. What is your bargaining style? Bargaining style is very important. Okay. Successful negotiation depends on three things. It's the bargaining position, how each party perceives their position, and your style. Are you a facilitator? Or are you a pit bull? Okay, are you somebody who goes for the jugular every time? Are you going to fight like a jerk over every point? Or are you someone who's going to try to get the deal done? Very often in a negotiation during the initial meeting, I will look the other side squarely in the eye and I will say, right now, you are looking in a mirror right now. How you treat me is how I will treat you. If you want to be proactive, if your client really wants to get this deal done, I will respond in kind. If you want to be a jerk and fight over every comma and semicolon in this 50-page document because you want to run up a big legal bill, fine, I can do that too. The choice is yours. I've sometimes done that in negotiations. And again, it's one of those, because nobody expects it, all of a sudden I'm getting respect from the other side because they think, this guy is a jerk. Yeah. And by the way, you should not ever be afraid as an attorney of appearing to be a jerk, by the way. Part of what your client is paying for and paying good money for is the right to abuse your good name. Very often, I will play bad cop to my client's good cop. One of the most effective litigators I know is like this. I've met him socially. I've been out with his wife and my wife. We know each other. I've known him for over 20 years. If he were sitting at this table, you think he's one of the nicest, sweetest people you have ever met. But in any negotiation, he is a fist banger. He bangs his fist, he yells, he screams, he curses on the phone. He actually scares the dickens out of anybody else that he's negotiating with. And this is his style. He just acts like a jerk. And you know why he does it? Because a lot of times people will give him what he wants just to get rid of him and to get him out of the room. And it's a very effective negotiating ploy. He has a lot of clients, by the way, because he has that reputation. I'm not going to give you anything. Your position is BS, and I want my client protected, and I'm not going to leave this table until my client has everything that he wants, and he starts cursing and using the F-bomb and all this kind of stuff. And I'll tell you, this is if you can pull it off, it's a very effective technique. Having a reputation as being a mean motor scooter and a bad go-getter is not a bad thing for a lawyer. Look, let me be honest with you people. When you're a lawyer, nobody pays you to be nice. I hate to say it. These people are looking for a gladiator, a lot of them. A lot of my clients are looking for a gladiator, and boy, are they disappointed, because I sure as hell don't look like one. Let me be honest, let's be very honest about that. I wouldn't last long in the Coliseum. Let's just put it to be very, very, very honest. Okay. Another thing you got to think about when you're trying to prep for a negotiation, is this a one-shot deal, or is your client looking to build a relationship with the other side? This is very important. So, for example, if your client is negotiating a consulting contract with a big company where this is sort of just the first project and there's other stuff coming down, maybe you don't want to negotiate as hard as you might otherwise. If this is just a one-time blow-off, your client is going out of business, he's selling all of his excess inventory to somebody else, a competitor, he's going out of business, he's retiring to Florida, he's never going to come back, well, maybe that dictates one negotiating style. But if there's going to be repeat business down the road, you don't want to come across too hard, because the other side will remember that. They'll remember, boy, this guy was impossible to deal with. It took us 6 months to get this deal. I don't want to ever deal with this guy ever again. Let's get this one deal done, and we're going to find somebody else to do whatever. That's going to hurt your client. These are the things you have to think about when you're preparing for negotiation. Okay? Okay. The next thing you have to do when you're prepping, you have to separate the deal points and the trading points. What are the issues involved here that have to be negotiated? And all of the negotiating points you will ever deal with fall into two categories. They're either deal points or they're trading points. Deal points are the things your client absolutely has to have, or else he or she will walk from the table. And most clients are very vocal about this. They will let you know what they feel the deal points are. Anything that isn't a deal point is a trading point. Nice to have. If you can get it, great, go for it. But if you can't get it, the world's not going to come to an end. The client will probably still go forward with the deal even if they don't get it. Okay? Always ask for more than you think you're going to get. Don't just ask for the deal points. If after your initial meeting with the client you come away with a list of 3 deal points and 7 trading points, ask for all 10. Don't be afraid. A, you'll probably get more than you think you're going to get. You'll get a lot of those trading points. And B, even if you don't, you'll have something that you can trade off for one of your client's deal points. Very often, what's a deal point for your client is not a deal point for the other side, and you got to get, you want to have some stuff to trade away. If the other side. One of the biggest mistakes that negotiators make, novice negotiators, they only go in asking for the deal points. That doesn't leave them any room. So if the other side comes back and says, I can't agree to one of these, you have nowhere to go at that point. By throwing a few trading points, a few nonsense things onto the table, you've given yourself some play there. Well, look, my client really has to have this, Joe, but the other, I can give you on some of these other things if you'll let my client have that. Okay, we'll talk more about deal points and trading points later on. Okay, so now you prep for your negotiation, and now you're at the negotiating table, a table that looks very much like this one. In my experience, based on 35 years of doing this stuff, there are 3 stages in any negotiation. Now, sometimes they occur in exactly this order. Sometimes they're all mixed up, time-wise. But there are 3 stages in any negotiation. The first stage, and by the way, if you think about it, this is also like a poker game. The first is what I call the statement of position. You lay out your client's points. The other side lays out their points. I call that the statement of position stage. You're laying out your position, and you're seeing how far apart you two of you are. Very often, you're not very far apart at all. Then the search for compromise stage. Okay, and then the horse trading stage. Let's take each one of these. So first of all, you statement position stage, you lay your cards out on the table, your points, his points. Where there's agreement, you take it off the table. If you see that the two of you are taking the same position on something, take that off the table. The idea is to winnow this list of points down to the absolute minimum. So if there are 10 points on your side, 10 points on their side, and there's agreement on 4 of them, take those 4 off the table. Just at that point, put them in the document, bake them into the document. At that point, you're done. Okay? Now we've got 6 points left on the table. Now what we have to do is search for compromise. Is there a middle ground here? Your client needs this, my client needs that. But you know what? Really, Joe, I don't really think your client needs exactly that. What your client really needs is something much less, and we can give that. We understand why you're concerned about that. I can give you that, but what you're asking for here is way too broad. My client can't agree to this whole package of stuff that you're asking for, but we'll let you do that because we know you need to do that. That's an example of a search for compromise. You try to find middle ground, and very often you can reach the middle ground. Very often what the other side is asking for isn't exactly what they need. What's the old Rolling Stones song, Mick Jagger? You can't always get what you want, but if you try sometimes you get what you need. This is what the search for compromise is all about. You start out asking for what you want, but then you really focus, does my client really need this? Well, no, my client doesn't really need all that. What they really need, though, is the right to do that one thing, and I can get them there. I can get them that one thing. I think the other side will agree to that because it doesn't hurt them in any way. That's the game that you're playing, the wants versus the needs. That's the search for compromise. Then at the very end, you're probably going to end up with 1 or 2 points where simply there's no room for compromise at all. You know, your side has to have it, their side has to have it. In that case, there's only one solution, and that is the horse trade. Okay, look, we're down to these 2 points. We want to get the deal done. My client wants to do it. I'll give you this one if you'll give me that one. And that's it. Both of us will be a little bit unhappy, but at least we got something. And of course, in that case, you've got to make sure to talk to your client and find out, okay, we've only got 2 points left on the table. We're not going to get them both. Which do you care about the most? Which one? Which one am I fighting for here? And then offer it. And if you can get the horse trade, then you go forward. If you don't get the horse trade, then everybody goes home. Okay, those are the 3 stages in any negotiation that I've ever been in. Okay. Ruth's second law of negotiating, my mom's second law of negotiation. Never, ever, ever give up something without getting something else in return. Never make a gratuitous concession without getting something from the other side. Very important point for lawyers. Here are some examples of what I call Ruth's second law. I'll take $1 off the price, but then I have to add sales tax because otherwise it eats too much into my profit. I was going to eat the sales tax, but if you're cutting another $1 off the price, well, then I got to add the sales tax. That's a classic example of a horse trade. I could probably charge less for that job, but I'm very busy right now, so you might have to wait a while until I can give it the I use this one a lot. I use this one a lot because I am so busy. You know, the client wants something tomorrow, but it's a stupid little job and they don't want to pay the full price. My approach is, well, okay, I'll do it for that price, but I just got to let you know I got this really big project. You know, my editor at Thomson West, I have this law book update that's really due Friday. I could probably get to this sometime next week, but that's probably the best. Okay, I'll pay the extra price. Can you do it this week? Seriously, you have to do that with your clients sometimes. By the way, again, you're negotiating with your clients as much as you are the other side in a business deal. You know, I could probably charge less, but you're going to pay. You're not going to get everything you're going to get. You're not going to get superstar drop dead service for that kind of a fee. In fact, I had a client call me. It was 4th of July weekend a couple of weeks ago. I had a client call me at 4 o'clock on Friday. 4th of July weekend was something he wanted me to do by Monday morning. I was halfway out the door to drive up to Vermont for a mini college reunion. So I called him back. I always call back a client promptly, and I say, look, just to let you know, I'm kind of heading out the door to go to a college reunion. I'll feel badly if I really miss that. If you want me to work this weekend, I will tell you that my fee for doing this contract will be $5,000, flat fee. And please, I want the check by Monday. But I will do it. I will cancel my plans. I will, do this. Oh, okay. When can you have it next week? That's what usually happens. Whenever they put you in that position, of course, if you're an associate in a